So without taking more of the time, I'm sure people have a lot of things to do, and we are really grateful that you found the time to come and be with us. I'll invite the head of delegation of Icrc in Rwanda for his welcome remarks, and we'll kick it off from there. Thank you so much.
Representatives of the diplomatic community, representative of the Rwanda Red Cross, members of the panel of judges, deans of faculties, distinguished invited guests, ladies and gentlemen, I welcome you all to the second edition of the Rwandan National International Humanitarian Law Moot Court Competition, and thank you for attending this event. I would like to thank the law faculties who worked tirelessly to put together competitive teams for the competition. I have no doubt that the teams will demonstrate knowledge of and passion for international humanitarian law, as well as keen debate skills. It is our wish that students molded and prepared for professional life by universities, particularly those students who would have taken IHL modules, excel in their particular professional careers and influence the strengthening of IHL to protect civilians in armed conflict. The Icrc values opportunities such as this one to encourage the adherence to and implementation of international humanitarian law. It's the responsibility of governments, but also of academics, students, armed forces and security personnel, and the general public indeed, to work towards promotion of the fundamental principles of IHL. It's our hope that establishing this moot court competition in its second year now will contribute to increased knowledge of IHL in Rwanda, and that in turn Rwandans can contribute to increased knowledge of IHL in the region. We also value the opportunity to be a part of the organizing committee for this moot court competition. As the lawyers in the room will know, law students graduate with vast knowledge, but what is vital is to anchor that knowledge in practice. And that's exactly what mooting does. The Icrc aims to contribute to learning IHL by helping to make that learning more real. The questions to be debated in tomorrow's moot are certainly real, with some of the answers to those questions, yet to be found. But what is important is that every day we continue to search for those answers. Ladies and gentlemen, may I take this opportunity to thank again the organizing committee of the 2017 National IHL Moot Court Competition and the law faculties from the 4 participating universities for their support in the hosting of this event. We would also like to thank the chairperson of Rwanda Law Reform Commission for his kind support, including his willingness to address us later this afternoon as our guest of honor. With these few remarks, I welcome you all and hope that we have a fruitful discussion this afternoon, and I wish good luck to all the competitors from the 4 teams for tomorrow. Do well.
Thank you so much, the head of delegation. And on the point that he just made, that is what we're trying to achieve here, training future advocates, future lawyers, who will be able to grow this body of law, because certainly we are sure that law is an evolving domain and it grows. And we are certain that by increasing the knowledge and the expertise, we'll be able to influence the global stockings on this particular topic of international humanitarian law. Without taking more time, allow me to welcome some more welcoming remarks. I'm sure we would need those. From the Rwanda Red Cross, you're welcome.
Head of Icrc, members of diplomatic courts, delegation from the Army, representative of institution of higher learning, colleagues from the Icrc and the Rwanda Red Cross Society, students, our competitors, ladies and gentlemen, it is a great pleasure that I address you today on behalf of the Secretary General. Due to other reasons, he was not able to join us. Awareness creation on international humanitarian law is an important step towards ensuring compliance and respect to these shared principles aimed to ensure that humanity prevails even in the most complex situation of armed conflicts. As for the Rwanda Red Cross, and I will be right to say the Rwanda Red Cross movement increased knowledge of these rules is an important aspect in all our disseminations. The annual national ICL Moot Court competition comes to add to a mix of efforts towards increased awareness on these rules to various groups across the country, which include academia. Now in its second phase, though early to load gains, this is no doubt that this annual event is making commendable contribution towards nurturing IHL enthusiasts who will become the academic experts that will further grow this body of law and be instrument in fostering its respect. In this regard, I take the opportunity to thank the organization committee for their efforts and for the investment made on the Icrc part in making this competition possible. Without further delay, let me extend warm welcome to you all to this year competition. Marcos.
At this particular moment, we've been hearing about the organizing committee. Allow us to invite the chairperson of the organizing committee to give us his remarks, and he will also introduce us to the next session of the event. Thank you so much.
Thank you. Dear Chairperson of Rwanda Law Reform Commission and our guest of honor, dear diplomatic representatives, dear head of Icrc Kigali delegation, distinguished guests, dear participant, all protocol observed, dear students, ladies and gentlemen. I would like to begin by welcoming everyone to the second National International Humanitarian Law Moot Court competition in our country. Let me also thank the distinguished guests and visitors from different institutions who have taken their time for joining us. It's a clear sign of a great importance that you attach to this event. The International Humanitarian Law Moot Court competition is intended to encourage law students to become familiar with international humanitarian law, to help them improve their practical and their presentation skills. It intended also to develop and increase awareness of interest and knowledge of international humanitarian law. This competition is the second national AHL Moot Court competition. Like the first Moot Court edition, its organization is one of many initiatives undertaken by our universities, law schools in Rwanda in collaboration and with the financial support of the Icrc Kigali delegation. Let me stress here that we have been collaborating in various other activities, such as international humanitarian law roundtables for lecturers. Icrc also has been sponsoring some of our law students and lecturers participate in regional events such as regional international humanitarian law trainings, regional moot court competitions in Arusha, and so on. So I take this opportunity to greatly thank the Icrc delegation of Kigali for developing and promoting humanitarian law. Especially without its support, this moot court could not have been take place. Dear Chairperson of Rwanda Law Reform Commission, ladies and gentlemen, this is the one of a number of initiatives aimed at promoting international humanitarian law, and we hope for your support for the sustainability of our annual Moot Court competition and other initiatives in the future. Thank you very much for your attention.
Without any more time, I am assuming that right now we will have the honor of inviting the guest of honor, the chairperson of the Rwanda Law Reform Commission, for his remarks on this wonderful day. Thank you so much, sir, for being with us.
Excellencies representing your countries in Rwanda, Excellence, the head of the Icrc delegation in Rwanda, representatives of government of Rwanda institutions here present, Secretary General of the Rwanda Red Cross Society, representatives of institutions of higher learning, students of faculties of law from participating universities, ladies and gentlemen, all protocol observed, good afternoon. My apologies for the delay, this slight delay. It was due to unpredictable circumstances beyond my control. It was a cas de force majeure, but I will argue the students who are participating in this moot court not to use it as a defense, because when it comes to the protection of civilians' lives, that argument may become inoperative. It is really a great privilege and honor for me to have the opportunity to preside over this important event in Rwanda's journey towards strengthening compliance to international law as we begin the process for the second edition of the International Humanitarian Law Moot Court Competition 2017. And just to express my happiness, or for you to understand how I'm happy, because when I was still a lecturer at the School of Law at National University of Rwanda, one of the courses I used to teach was international humanitarian law. And I used to take my students in moot court, including international moot court. And I'm happy to see some of them here, including Emerance, who is there, as one of students who I used to take. And I do remember that we have always dreamed to organize a national moot court competition. Thank you, Icrc, for inviting me. And I could see also Sarah, we used to work together in matters related to international humanitarian law. I'm really grateful. The relevance and importance of this kind of exercise goes beyond its academic nature and tackles issues that are the very heart of the survival of millions of people facing various types of conflict in the whole world. And the reason why I was saying that students should not use my argument or my excuse as a defense is because for many victims of today's conflict, compliance with international humanitarian law is a matter of health and death. And as you know, this country's recent history, which is just 23 years old, was born from the worst genocide experienced by humanity, given the speed of massacres and the despicable acts that characterized the 1994 genocide against the Tutsi in Rwanda. And during that period, none of the principles established by the four Geneva Conventions and their additional protocol was left unviolated by the crimes committed during the 3 months of the genocide against Tutsi. And this serves to remind us that the consequences of the failure to stand firm in defense of IHL principles go beyond simple legal terms and may have a catastrophic impact on the everyday lives of many innocent civilians. And we are here, and during this period, we are in the age where IHL is more challenged than ever. The classic actors in an armed conflict have tremendously changed to include the most unsuspected ones. There is an increase in the use of new sophisticated technologies never witnessed before, which comes with its toll on the lives of civilians. While the complex nature of contemporary conflict continues to challenge the application of IHL rules on a daily basis. And when I was reading the agenda, today's agenda, I was happy to note that this afternoon we also have a public lecture on IHL and terrorism. As important as complying with the rules of IHL is its knowledge by all concerned actors. And this national IHL Moot Court competition and the public debate we will have here today serve this purpose of promoting international humanitarian law to our community in its entirety. And on this note, allow me to thank the components of the Red Cross movement, particularly the Icrc and the Rwanda Red Cross, for the investment of time and resources in pursuing this noble cause that has gathered us here today. I would also like to appreciate the participating universities for their strive for academic excellence and encourage them to continue their effort in this interview. I could see my former colleagues, lecturers here present. Thank you for being here and thank you for striving for this academic excellence. Last but certainly not least, my appreciation goes to the students who will be competing for their commitment to improve their knowledge of international humanitarian law. This is a useful opportunity for you students to develop your pleading skills as future law professionals, but also interact with the various experts here present on practical aspect of the theological principles you have been learning in school. And I argue to use it effectively. With these remarks, I announce the second National International Humanitarian Law Moot Court Competition 2017 officially open, and I wish our students the best of luck. However, as a lecturer, I must underline that the luck will certainly go to those who are well prepared for the task ahead. Thank you, Excellencies. Ladies and gentlemen, God bless you.
Actually say, while it's going to be a presentation on the Icrc, I am sure it will be a presentation on the Red Cross movement. Emeanse will give us a little bit of that on the Red Cross movement. Emeanse, you're very welcome.
Thank you, Matthew. Indeed, you are right. It's more about the Icrc within the Red Cross movement. Okay, so the story begins with one man. I'm sure most of us here might have heard this story, but in case there might be one or two or a few of us who have not yet heard about this story, it begins with a man, a Swiss gentleman, a businessman called Henri Dunant. He was on a business trip. We are back in 1859, many centuries ago. And it was business as usual, but when he reached a place called Solferino, he found a battle taking place, a battle between two parties, if I may call them that, between the French on one part and the Austrian army on the other side. So, as you might know, as in any battlefield, there were many wounded people, many wounded members of the armies, as well as other civilians affected by that battle. So he felt touched by what he saw. He saw a lot of pain, a lot of people wounded. So it gave him, he went back and had an idea. And with that, he thought it would not be good or great to stay with the idea by himself. So he engaged a process of sharing his idea through a book he called The Memory of Solferino. And in the book, two great ideas came to be. The first one was a suggestion by Henri Dunant to create a volunteer medical service that's obviously to help all the wounded during the battle. And the second idea was to create an international agreement, an agreement that would be as a guideline for the troops taking part in the battles to make sure that the wounded is attended to, is cared for. So Henri Dunant shared the book, and I might say this suggestion, this idea of creating an international agreement on the protection of the wounded will later give birth to what we know today as the rules of the war, or Icrc. I will spare you the history and the background of the movement, how it evolved and came to be. I would just say that from his suggestion that there be a creation of volunteer movements was born the idea of the Red Cross societies as we know them today. And from the Red Cross societies, we later had the International Federation of the Red Cross Societies, which are an umbrella organization that brings together all Red Cross and Red Crescent societies in the whole world. And we also have the Icrc, the Icrc, which I'll talk about more in details in the following slides. So the the National Red Cross Societies, the International Federation, and the Icrc together form the Red Cross movement. And the Red Cross movement is guided in its day-to-day activities by 7 fundamental principles. I will not go into details about them. As you can see, I try to say in brief what every principle means, but there's a lot more when we go into practical details of every principle here than we have time to discuss today. But I think by the end of the presentation, I'll just, or even now, please feel free to contact us or visit our website for more about these fundamental principles and how we work in practice. So who are we as the Icrc? The Icrc is an international organization. It's a Swiss international organization. But what's more about that is its nature, its unique nature, if I may say. It's an impartial, neutral, and independent organization that is shared by so many other humanitarian organizations. But we will see in which respect we say it's a bit unique. And the Icrc aims for 2 important objectives. The first one is to protect. And protect who? The victims of armed conflicts. And the second one is to assist them. So basically, the Icrc do 2 things. It ensures protection of victims or people who are not taking part in an armed conflict, and it assists them. It's been there, as most of us know, for more than 150 years now, and it has a global presence. We have delegations, I think, in almost every country of the world by now. And what's worth mentioning about Icrc, I said earlier that it has some kind of special status. What makes it special, one of the factors is this. It has been given an international mandate by the international community. So it states that mandated the Icrc to do what it does. And as I said, it consists mainly in the protection and assistance of victims of armed conflicts. So the activities of the Icrc may be grouped in 4 pillars: protection, prevention, assistance, and cooperation. When we talk about protection, we are mainly making reference to activities such as visits to prisons to ensure during an armed conflict, we are referring to visits to prisoners of war and civilian internees. But we also, and that's an example in this country, we also conduct visits in places of detention, not only during armed conflicts, but also during peacetime, to make sure that the conditions in places of detention meet international treatment of detainees standards. And this is in accordance with the same international mandate that was given to the Icrc. The Icrc, in that respect, acts as an international monitoring body accepted and sent by the international community to ensure that detainees are held according to international standards. And also in the protection pillar, we have activities such as reuniting family members that were separated as a consequence to armed conflicts. So as we call it, usually reuniting family links. And we have so many examples in the Rwandan context where people, due to the genocide and the civil war from 1990s, people were displaced and many families were separated, with some of the members being here in Rwanda and others scattered across the East African region. I think up to this year, I think I've had my colleagues from the department say that even up to this day, I think it was last week, that we were contacted by someone who had just had news from their relative who was in Congo. So you can imagine 23 years later, this is still relevant. And the prevention part of the Icrc work, a very obvious example is what we are doing today. The Icrc has been always referred to as the guardian of IHL. That means the Icrc ensures knowledge and respect of the rules of IHL. And part of doing that includes creating awareness on IHL. And we do that through activities such as this one we're having, and it's in the it's in the framework of the activities we have with academic circles. We organize events for both university professors and students, such as roundtables for IHL lecturers to meet and discuss on how they can improve the teaching of IHL and share on the challenges they meet and best practices. We also have this kind of competitions for mainly law students, but in other settings you might even have competitions for other students, like students in journalism or medicine, depending on the relevance of IHL in a given context. We also do what we call, on a higher level, we have IHL diplomatic dialogues, whereby on a high level, Icrc leadership engages with various leaders from across the globe. You will hear about summits, different international conferences organized by the Icrc about the development of IHL. For instance, the Icrc has been playing a big role in engaging states on the development of specific IHL treaties and conventions. For instance, the Convention Against the Use of Cluster Munitions and the Arms Trade Treaty, which is the recently signed and ratified by many states convention against the production, the transfer, and the use of certain weapons. We also do assistance. This is mostly during the acute period of an armed conflict, where there's need by different victims of armed conflicts of the basic needs, such as water, shelter, food. We provide those to displaced, to people in detention, but also later on, when the community is trying to rehabilitate or to reestablish itself in the aftermath of an armed conflict, the Icrc has financed or sponsored projects aimed at reconstructing societies affected by armed conflicts. We also have rehabilitation centers for those physically affected by the conflict, such as war casualties, where we provide alternative physical. I'm running short of the technical term, but we have rehabilitation centers where we provide the medical and physical assistance to those affected by different conflicts. And finally, in the cooperation area of our activities, this is where we work hand in hand with national societies of Red Cross and Red Crescent, in this case with the Rwandan Red Cross Society. I should have invited Matthew to talk more about this, but we have different projects we work together on, including this activity. Since the Moot Court started, we've been working together to organize and deliver this activity. But apart from that, we sponsor different projects by the National Red Cross Society, including trainings on first aid and safer access for Red Cross volunteers and so many other activities. In short, that's who we are, that's what we do. If you have other questions about who we are and what we do, feel free to raise them during the discussion part of this event. But you can also visit our website for more information. Thank you for your attention.
Thank you, Emerance, for the presentation on the Red Cross movement. Emerance, it's always very beautiful to hear people talk about you. So thank you for not inviting me to talk about the Rwanda Red Cross. It's always good when someone else says what it is. Right now, I should say we are going to go into the gist of the presentations for today. In the organization, we call this evening a public lecture. I hope that Sarah is going to lecture to us. All right, so allow me to welcome our colleague Sarah Swart. You're very welcome for the presentation on IHL and terrorism. So, karibuni.
Great, thank you very much. Thank you, Matthew, and good afternoon to everybody. I know I'm the last person today, so I'm not going to speak for too long, I promise. But I did want to address you this afternoon on something that I think is very important, something that's very interesting, and that's the question, is terrorism a challenge for IHL? So let me start with the first slide. I wanted to tell you today that in the ICRC's opinion, and in my own personal opinion, terrorism is a phenomenon that the international community has been striving to address for decades. The obvious challenges that terrorism poses are not only immediate, but they are also long-lasting. Wherever we turn these days, across the world, we are confronted with risks, increased risks, of terrorist acts. And it's really, I think we can say safely that terrorism is really a global phenomenon, sometimes closely linked to armed conflict, sometimes not, and one which the international community is increasingly facing. It's important for us to remember at the start that terrorism cancels or negates the fundamental principles of humanity, as well as the recognized principles and objectives of international humanitarian law, or IHL. In this regard, the ICRC completely condemns acts of terrorism, irrespective of who commits the act, who the perpetrator is, and whether or not they are committed inside an armed conflict. The ICRC is deeply distressed by the devastating impact of terrorism on communities, but also on individuals. Indeed, every day, we see the dramatic consequences of the fight between states on the one hand, and non-state armed groups on the other hand. And these non-state armed groups are sometimes, as you may be aware, labeled or designated as terrorist armed groups, often by the countries in which they find themselves. And this particularly happens on our own continent, Africa. Irrespective of the claimed legitimacy of this fight or the causes that the non-state armed group espouses, what we observe in the field is once again, it is the civilian population who bears the brunt of the armed violence. We've seen it on TV. I know we've all seen it in the news. Cities are reduced to rubble. Civilians are directly attacked. Humanitarian and medical personnel, transport and infrastructures are targeted, and they are prevented from fulfilling their functions. The civilian population, you and me, we are directly attacked. We are deprived of supplies that are essential to our survival through siege warfare. Humanitarian access is denied, and resulting from all of this, what we see daily is hundreds or thousands of people being internally displaced or fleeing their country, leaving a home, a job, a plot of land, or even close relatives behind. In the absence of a political situation, compliance with IHL and the fundamental values of humanity are required more than ever from all sides. I must just say at this point that this morning we had a short workshop with the students who will be part of the Moot tomorrow. And I was very encouraged. We were talking about something very technical, which was qualification of armed conflict. And then we were talking about something very personal, something very significant, which is sexual violence in armed conflict. And what struck me from the students who are in the room with us now is that at all times the students kept bringing the issue back to the principle of humanity. And I think that's excellent, because even though we're lawyers, even though we look at the black and the white of the law, even though we look in textbooks every day, we have to remember why we do it, and it's because of humanity. And so I must congratulate the students on that and encourage them to maintain that in the Moot Court tomorrow. Now, the rise of non-state armed groups resorting to acts of terrorism is a growing concern, I think, at the domestic level, but it's also certainly a growing concern at the international level. This situation has led states and international organizations, including the United Nations, to react by tightening existing counterterrorism measures. Now, you may have heard of it, preventing violent extremism, countering violent extremism. Those are very trendy terms at the moment. We'll speak a bit more about that in a moment. And while the Icrc, of course, understands the need for states to take legitimate measures to ensure their security, there is a concern that while taking such measures to eliminate terrorism, the safeguards protecting life and upholding dignity must still be kept. In the Icrc's view, the international community needs to be clear and firm on the requirement that counterterrorism activities be conducted in full respect of the protection afforded to all individuals by international law, in particular IHL, of course. Now, neither armed conflict nor terrorism are new forms of violence. Both have existed for a long time, unfortunately, and have for the most part been understood to be quite separate. The idea that armed conflict and terrorism are different and that their respective legal rules are distinct has, however, radically changed since 2001, and the subsequent launching of the so-called global war on terrorism, which I'm sure all of you are familiar with. Recent years have again seen the rise of non-state armed groups resorting to acts of terrorism and the subsequent engagement of coalitions of states against those groups. This situation has put the relationship between IHL and the legal framework governing terrorism right back into the spotlight, and may have even created the perception that there is a new global war on terrorism involving a group or groups of unbounded geographical reach. Is this true? What is this so-called war on terror? Well, this is a term that has been used to describe a range of measures and operations aimed at preventing and combating terrorist attacks. These measures are quite wide. They could include, for example, intelligence gathering. They could include financial sanctions, even judicial cooperation between countries. They could also include armed conflict. Now, the legal classification of what is often called the global war on terror has been the subject of much controversy. While the term has become part of our daily use in some countries, there does remain a need to examine, in the light of IHL, whether it does truly refer to a global armed conflict in the legal sense. Based on an analysis of the available facts, the Icrc does not share the view that a global war is being waged. The ICRC rather takes a case-by-case approach to the legal classification of situations of violence that are often referred to as part of this war on terror. So, to put it simply, where violence reaches a threshold of an armed conflict, whether international or non-international in character, IHL will apply. Where it does not reach the threshold of an armed conflict, other bodies of law come into play. For instance, specific aspects of the fight against terrorism launched after the attacks against the United States in September 2001 do amount to an armed conflict under IHL. The war waged by the US-led coalition in Afghanistan that started in October 2001 is an example. The Geneva Conventions and the rules of customary international humanitarian law were fully applicable to that international armed conflict, which involved the US-led coalition on the one side and then Afghanistan on the other side. However, much of the violence taking place in other parts of the world that is usually described as terrorist is actually perpetrated by very loosely organized groups or individuals that at best would share maybe a common ideology. It's doubtful whether these groups and networks can be characterized as a party to any armed conflict. What's interesting, I read this on the ICRC's website, and I really liked this quote. Terrorism is a phenomenon. Both practically and legally, war cannot be waged against a phenomenon. War can only be waged against an identifiable party to an armed conflict. For these reasons, and at least in the ICRC's point of view, it would be more appropriate to speak of a fight against terrorism rather than a war on terrorism. So let's look in a bit more detail at exactly what IHL does say about terrorism. Well, what's interesting, I think, is that IHL does not actually provide a definition of terrorism. In fact, there's no globally agreed definition on terrorism today. What IHL does do, however, is it prohibits most acts that are committed in armed conflict that would be considered as terrorist acts. For example, it's a basic principle of international humanitarian law that persons fighting in armed conflict must at all times distinguish between civilians and combatants and between civilian objects and military objectives. This principle of distinction, as I think everyone in this room knows, particularly our students, is really the cornerstone of international humanitarian law. So many of the IHL rules aimed at protecting civilians are derived from this principle. IHL also prohibits hostage taking. There's nothing to gain from describing these acts of violence against civilians or civilian objects in situations of armed conflict as terrorist, because such actions already exist and already constitute serious violations of IHL. In addition, international humanitarian law specifically prohibits measures of terrorism and acts of terrorism. So for the lawyers in the room who like specific provisions, you can have a look at Article 33 of the Fourth Geneva Convention, which states that collective penalties and likewise all measures of intimidation or of terrorism are prohibited. Another example would be Article 4 of the Second Additional Protocol to the Geneva Conventions, which prohibits acts of terrorism against persons not or no longer taking part in hostilities. Now, the main aim of these provisions is to emphasize that neither individuals nor the civilian population may be subjected to collective punishment, which, among other things, obviously terrorizes. Additional Protocols 1 and 2 also prohibit acts that are aimed at spreading terror among the civilian population. Article 51 says, acts or threats of violence, the primary purpose of which is to spread terror among a civilian population, are prohibited. But what we must keep in mind is that these provisions that I've just quoted to you do not prohibit lawful attacks on military objects. Okay? The aim of international humanitarian law has never been to prevent war. So lawful attacks on legitimate objects remain allowed. What is prohibited is a specific aim to terrorize civilians. For example, conducting shelling or sniping campaigns against civilians in urban areas. That would clearly be an act of terrorism. As IHL applies only during armed conflict, it does not regulate terrorist acts that are committed in peacetime. Such acts are, however, subject to law, that is domestic and international law, in particular, human rights law. Irrespective of the motives of the perpetrators, terrorist acts that are committed outside of armed conflict must be addressed in a different way. They must be addressed by domestic or international law enforcement agencies. States can take several measures to prevent or suppress terrorist acts. So these would include intelligence gathering, police and judicial cooperation together, extradition where necessary, criminal sanctions, financial investigations, the freezing of assets, or diplomatic and economic pressure on states accused of aiding suspected terrorists. Now, I mentioned it earlier, and I just want to touch on this briefly before I move to the next point. One must also consider the fight against terrorism, not just terrorism itself. So this is often referred to as counter-terrorism. The truth is that the fight against terrorism can take many forms, even armed conflict. Now, determining when IHL applies to particular counter-terrorism activities is not always easy, not only because some states would deny the applicability of IHL on the basis that the non-state armed groups designated as terrorist cannot be considered party to an armed conflict. That would, of course, give that non-state armed group a measure of legitimacy, which a government may not choose to do. Now, how, when, and where IHL applies to terrorism and counter-terrorism activities still raises important questions, and I'll just list some of those questions for you. Firstly, it's important to recall that any use of force against non-state armed groups designated as terrorist does not necessarily amount to a situation of armed conflict governed by IHL, and when armed force is used, all we can do is look at the facts on the ground. That's the only way to judge whether IHL will apply to the counter-terrorism measures. Secondly, a crucial question relating to IHL applicability is whether non-state armed groups designated as terrorist fulfill the organization criteria for classifying a situation as a non-international armed conflict. Now, this is very difficult today. Why? We see many fluid armed groups, we see many multidimensional armed groups, we see many fragmenting armed groups around the world operating. And how do we tell whether those armed groups have the level of organization and structure and command control within them to qualify as an armed group in a non-international armed conflict? It can be a very difficult judgment to make. Thirdly, we have to consider the spillover of conflicts into neighboring countries. This really appears to have become a distinctive feature of many of the armed conflicts around the world today, involving non-state armed groups. This transnational nature of armed conflict in various countries really raises the question of the territorial reach of IHL. I'm personally fascinated by this question: how far can IHL apply? We don't have time to discuss it today, but I would encourage the students, those of you who are interested in pursuing IHL and looking for a dissertation topic, this is a very interesting one. Okay. Just to conclude on this point, IHL has been sometimes described, including by recently elected presidents, I won't name who, as a set of rules that hinders or weakens the efforts of states to efficiently address their security concerns. Now, of course, the Icrc does not agree with this statement. On the contrary, IHL can be a powerful tool at states' disposal while still providing important protections for those affected by the armed conflict. The added value of IHL is really significant in this regard. There's one point that I would like to make very briefly. I feel like I've been talking for a long time, so don't worry, I'm coming to an end. But I wanted to talk to you about something that we often hear about in the news or in the media, and we don't really know what it means in terms of IHL. And that is the concept of foreign fighters. Has anyone heard that in the media? Anyone heard of foreign fighters? Am I the only one? Okay, I see some hands. Good, okay. So this phenomenon of so-called foreign fighters is referring to nationals of one country who travel abroad to fight alongside a non-state armed group in the territory of another state. And we're really seeing an increase in this in recent years. I know in my country, in South Africa, we always consider ourselves quite safe from armed conflict, perhaps a bit arrogantly so or naively. We don't think that armed conflict will come to us. And what has happened recently, we have a number of young, I would say young adults, teenagers, who we have recently found out have been supporting the Islamic State, some of which have traveled to other countries to take part in combat activities. 2 of them have returned to South Africa and are now facing trial under South Africa's terrorism legislation. So this is really a real issue for us. What I would like to say is that states, in responding to this threat, have taken a variety of measures, including the use of force, detention on terrorism charges, and travel bans. Is this working? Well, most of the measures that are taken to prevent individuals from joining these groups or to mitigate the threat that they may pose when they come back have really been of a law enforcement nature, not of a military nature. So the applicability of IHL has perhaps been overlooked to date. Little attention has really been paid to how IHL deals with the phenomenon of foreign fighters. The first point that I have to make, and I think it's on the slide, is that the concept of a foreign fighter is not a term of art in IHL. If you read the Geneva Conventions and the additional protocols, you will not find the words foreign fighter. The general applicability of IHL to a situation of violence in which such fighters may be engaged doesn't depend on the nationality of the people fighting. What it depends on is only the facts on the ground and on the fulfillment of certain legal conditions stemming from the relevant norms of international humanitarian law. So in other words, in situations of armed conflict, IHL will govern the actions of foreign fighters as well as any actions against them by parties to the conflict. In situations of armed conflict. Let's not remember that phrase, forget that phrase. So in this regard, it's really important, I think, to underline that foreign fighters who are detained in relation to an armed conflict will benefit from the protections afforded by the applicable IHL rules, irrespective of the domestic laws that govern that person's detention. Unfortunately, states dealing with this phenomenon of foreign fighters tend to shy away, I think, from recognizing the applicability of IHL to those that they detain. So finally, I would just like to say a few words on counterterrorism legislation. So I've referred a bit to counterterrorism throughout this presentation, and I would just like to say that since 2011, the ICRC has, on various occasions, shared its concerns with the international community that counterterrorism legislation has the potential to over-criminalize. What do I mean by that? Well, a number of pieces of legislation that are being adopted by countries to fight against terrorism are saying that any humanitarian assistance given to a terrorist organization is illegitimate. Any funding that goes to a terrorist organization is prohibited. Any type of assistance will be prohibited and punishable. Can you see the potential danger in a law like that? The potential danger, of course, is that these laws could, in practice, actually criminalize the core activities of impartial humanitarian organizations and their personnel that are endeavoring to meet the needs of victims of armed conflict or situations of violence below the threshold of armed conflict. In addition, the potential criminalization of humanitarian engagement with non-state armed groups and of humanitarian activities carried out in areas controlled by these groups may be said to reflect a non-acceptance of the idea of a neutral, independent, and impartial humanitarian action. And this is an idea which the ICRC strives to promote in its operational work in the field. So the ICRC has tried to persuade states to stop legislating against principles that they have supported and endorsed through IHL treaties, as well as to ensure that the new legal frameworks that are developed as part of counterterrorism strategies do not challenge principled humanitarian action. So far, the ICRC has not been as successful in this area as we would have liked. But we are convinced that stakeholders will understand the necessity to harmonize their policies and their legal obligations between both the counterterrorism and the humanitarian realms. But this is something that we really still need to work and focus on. So to conclude, I have a nice cartoon for you there. And I just wanted to say that, again, the ICRC strongly condemns acts of violence that are indiscriminate and spread terror among the civilian population. We have done so on numerous times and will continue to do so. The ICRC's case-by-case approach to the legal qualifications of situations of violence is also applied to determine the status and rights of persons who are detained in the fight against terrorism. Terrorism really negates the fundamental principles of humanity. I said that at the start of my presentation, and I wanted to repeat it now. It is contrary to the core objectives of international law, including IHL. The ICRC condemns all acts of terrorism, whether committed within or outside armed conflict, and irrespective of their perpetrators, and is alarmed by the harmful effects of these acts on countries, on communities, and individuals. This is really an area of the law that is of interest, that scholars and academics are writing on, and I'd really encourage the Rwandan scholars, academics, and students to add their voice to this debate. Thank you.
Thank you so much, Sarah, for the presentation. And I'm sure perhaps I'm not the only one. There are other people who have questions that they want to ask regarding the law, IHL, as far as terrorism is concerned. So yes, the time is yours. The floor is open for the questions. If you have any question you want to ask, some comment you want to make, I am sure in the room we have some other legal experts on issues regarding the laws of war. We would really welcome comments on this. Terrorism is a very, should I say, it's a hot topic right now as far as IHL is concerned. Questions are really many, and I don't think the answers are as many as the questions. So comments are really welcome so that we can discuss this topic. Thank you so much. So we can take the first maybe 3 questions and then answer those, and then, or maybe comments, and then we'll go back and take the next round of questions. Maybe we can do that for 2 rounds, and then we'll close it. Thank you.
Pumwide Sharon, and my question is, if there is no international recognized definition of terrorism, what is based on for some acts to be classified as those that cause terror among the civilians, or those that are regarded as terrorist acts? What is based on? Thank you.
My name is Kennedy. I have a comment just to add on terrorism in the context of IHL. I believe that as long as we have the gray areas, one of them being that we don't have an internationally recognized one definition of terrorism, it will still remain a challenge. Reason being is that to some quarters, terrorism defines their means of expressing self-determination protected under civil and political rights, the Convention on Civil and Political Rights. And then to the other quarter, they look at terrorism as people who are advancing using threat, fear to achieve their intended goals. And when I talk about intended goals, there also we have a gray matter. And what do I mean? On one side, there's a school of thought that terrorists, they want to achieve political goal, and another side, they want to achieve religion goals. With the political goals, I think we have international instruments that can guide on that. It now complicates, or it compounds this further. Would you want to now affiliate terrorism and religion? And if you look at the international human rights law, religion is one of the protected rights, even in most of the constitutions of modern states, if I don't want to use the term civilized states. So the moment a religion is mentioned and attached to the terrorism, it becomes a live wire. Now, another thing is that at what point do we say that terrorism is affecting us? One being the bone of contention in the Middle East, whereby Saudi Arabia is in a hot soup with its partner states or neighboring states. I think all of us know about this. So if you look at and you follow up whatever is happening, then it leaves a lot to wonder that at what point are we all going to agree that terrorism is this kind of crime, whether domestic or internationally, but having harmonized, elements that constitutes it. Just like other customary laws have been codified, I think until we reach that point, that's when we can address terrorism under international law. Thank you.
Yes, my name is Robert Maraga. I picked interest on the over-registrating statement because indeed, considering the existing legal instruments, you may say that states are over-registrating. But again, these states will tell you that they are I mean, they are doing everything possible to protect their sovereignty and the interest of their citizens. And by this, I wonder, how do you think this will be addressed? Is it time to have another international legal instruments, maybe that provide model provisions to deal with terrorism, that, I mean, with provisions that are in harmony with the existing legal instruments? Do you think this is the time? I thank you very much.
Okay, thank you for those questions and the comment. I think maybe I'll start with the last one. You're absolutely right that states have a legitimate prerogative to look after the security of their country and of their citizens. That's absolutely true. I think where the concern comes in is where that protection has an impact on humanitarian assistance. So for example, for those of you who know the Common Article 3 to the Geneva Conventions, which covers non-international armed conflict, and Additional Protocol 2 to the Geneva Conventions, it quite clearly states that the ICRC has the right to offer its assistance, its humanitarian assistance, to come into a country where a non-international armed conflict is ongoing and to provide that neutral, impartial, and independent humanitarian assistance. It's not only in the Geneva Conventions and the additional protocols, it's also actually in the statutes of the Red Cross, Red Crescent movement, which states adopted at the global level. And so there's a concern that by, as I said, over-legislating or by making the reach of criminal assistance too broad, there's a concern that it's cancelling out this right that governments have already given to humanitarian organizations to offer their assistance. As to the question about whether now is the time, that's a very hard question to answer. I must just say, and I think this would also address the first question, that there isn't a complete vacuum. So states have been discussing terrorism and counterterrorism for a long time, and there are a number of United Nations resolutions, for example, that deal very specifically with this issue. So we do have some soft law in that regard. I think the problem is that, it's like the crime of aggression. It took decades for the international community to agree on a definition. And I think this is just one of those things that will take time. Whether now is ripe for that discussion or not, I'm not sure. We'd have to ask some other people in the room, I think. Thank you. Oh, I didn't answer your question. I just wanted to say, you were talking about why there's no definition of terrorism. Okay, I don't really have anything more to say on that. It's a tricky issue. How do we know what terrorism is if we don't define it? So today we're here to talk about terrorism and armed conflict. And in armed conflict, under IHL, we do have an understanding of what terrorism is. So if we go through those provisions that I mentioned, we see quite clearly very specific crimes or offenses which would constitute terrorist acts under IHL. Outside of IHL, do we have an agreed definition on terrorism? No, but we do have efforts towards it through these UN resolutions that I was referencing.
I want to thank you so much for being with us today. I want to thank you for the attention and for staying this long and following through with the presentations. And I think we'll show you the way, the Emerhans and the hotel, and the rest of us will lead you to where the cocktail is. Thank you so much. Have a nice evening.